On the 10th day of December, a quiet yet important conversation resurfaced across public forums, community discussions, and policy circles. It is a conversation rooted in timelines, official processes, legal expectations, and the way national institutions handle complex issues over extended periods. Throughout the past months, several developments have unfolded one after another. Some of these events were public, recorded in news bulletins and formal statements. Others emerged as interpretations, commentary, and analysis from observers trying to understand what each new piece of information meant for the larger picture. Today's documentary follows that timeline step by step, connecting the dates, the statements, and the gradual movement from formal legal proceedings into broader discussions about political processes and policy pathways. Everything here is presented in calm, factual language, focused on clarity and understanding. To make sense of the current timeline, we must begin from the 20th of November, a day that brought renewed attention to ongoing legal matters as court decisions, public reactions, and official communications aligned to create a new phase of national discussion. The days that followed saw commentaries from prominent individuals, analysts, and public figures. These contributions did not change the legal framework, but they shaped the national conversation by offering interpretations of what might come next, based strictly on lawful procedures and political norms. From the 21st to the 22nd of November, several public statements highlighted optimism for dialogue, suggesting that conversations around political solutions, when appropriate and lawful, could complement existing judicial processes. These comments were widely shared and analyzed, not because they represented immediate action, but because they hinted at possible future direction. As different voices expressed their perspectives, analysts began paying closer attention to what could be inferred from official remarks. In these kinds of situations, clarity often comes not from one bold announcement, but from a series of small signals, each one adding a layer of meaning to the broader picture. By the end of November, the national atmosphere had shifted slightly toward curiosity and cautious expectation. Many observers wanted to know what the next step would be. Others examined how similar issues had been handled historically, comparing timelines, legal processes, and possible outcomes under constitutional frameworks. Around this period, meetings took place in the capital. Meetings that were not unusual but nevertheless attracted attention because of their timing and the individuals involved. These discussions, as reported, covered various governance matters. However, because national issues often overlap, commentators naturally speculated on whether broader matters might also have been included in the conversations. This documentary does not claim insider knowledge of private meetings or confidential discussions. Instead, it follows the publicly available timeline, interpreting it through the lens of policy analysis and established legal procedure. And so, as we move deeper into this exploration, one important theme emerges: the relationship between judicial timelines and political timelines. This relationship has shaped the expectations surrounding many national matters, and today's subject is no different. To understand what might happen in the coming months, we must first examine how appeal processes work, what each stage means, and why these stages often determine when other forms of resolution can be considered. But before we get there, we must revisit the final days of November, a period in which several key meetings took place, creating a foundation for analysis that continues into December. Toward the end of November, public attention shifted toward a series of visits by state leaders to the nation's capital. These visits are common in governance. State executives frequently meet with federal authorities to discuss development, security, budgets, and intergovernmental cooperation. However, because these meetings occurred soon after renewed legal activity, many observers began linking the timing with expectations for broader national conversations. It is important to emphasize that such analysis remains interpretive, not official. The first meeting, reported around the 28th of November, involved discussions on economic matters, local development, and intergovernmental collaboration. Yet in the eyes of analysts and the general public, the close timing created a sense of possible significance. A few days later, in early December, another meeting took place, this time bringing additional attention because aides and spokespersons publicly commented on general themes such as dialogue, peace building, and long-term stability. These remarks were carefully phrased and did not disclose private discussions. Public officials often maintain confidentiality around sensitive topics, as required by protocol. Still, even the broad language used was enough to spark conversation. From these comments, analysts identified two possible interpretations. First, that leaders were exploring avenues for reducing tensions, enhancing unity, and promoting harmony across regions. Second, that any such pathways, if ever pursued, would require alignment with existing legal processes. This is where the storyline becomes especially important. Because once legal proceedings begin, especially at the appellate level, the timelines become structured and predictable. Courts operate according to fixed schedules, procedural rules, and statutory requirements. Meaning, legal timelines cannot be bypassed, rushed, or overridden by informal conversation. This is why many analysts began paying attention not only to political signals, but to the appeal timetable itself. If political pathways require space, and if that space cannot exist while major appeals remain active, then naturally the question becomes, how long will the appeal process take? And this is the question that ultimately frames the entire documentary you are listening to. In legal systems around the world, appeal proceedings exist to ensure fairness, to allow review of lower court decisions, and to strengthen confidence in the justice process. Appeals are methodical by design. Each step requires documentation, review, and sometimes multiple hearings. Analysts examining this situation closely concluded that any expectation of major political action, if it were ever considered appropriate, would naturally depend on the appeal running its course or reaching a procedural conclusion. This led to the development of a projected timeline, one rooted not in speculation but in established legal procedure. In the next part of this documentary, we will break down that timeline in detail, step by step, showing how each phase informs the next, and why observers believe certain dates in the coming year carry significant weight. As we move into part 2, we will explore the full appeal sequence, projected windows for hearings, and what each month of the upcoming year could represent for analysts following this development. To understand the timeline analysts are now discussing, we must look at the structure of the appeal process itself. Appellate procedures follow a predictable rhythm. Documents must be compiled, transmitted, reviewed, and scheduled for hearings. Each step is essential and none can be skipped or rushed. In this section we explore the appeal timeline as analysts project it, based entirely on standard legal procedure. Nothing here is speculative about outcomes. This is strictly about process, timing, and why these steps shape public expectation. Preparation of records, late 2025. Any appeal begins with the preparation of the record of appeal. This includes proceedings from the trial court, exhibits tendered, court rulings, filed motions, certified transcripts. This stage is often slower than the public expects. Transcripts must be verified, documents must be checked, procedural accuracy is essential. Analysts note that in many cases record preparation can take weeks or even months, depending on the complexity of the file. During this phase there is little visible activity. But beneath the silence, clerks, lawyers, and administrative officers are performing detailed work. Observers understand that until this phase is completed, the appeal cannot move forward. Scheduling of preliminary motions, early 2026. Once the record is ready or near completion, the courts typically fix a date for mentioning the case, hearing preliminary motions, discussing record transmission, confirming readiness for the appellate stage. Analysts following this process anticipate that this preliminary mention could fall around late January, based on typical procedural calendars. At this point, nothing substantive is argued. Instead, the court confirms that the case file is ready to ascend to the higher court. This early procedural mention has no impact on the broader political landscape. It is simply a necessary legal milestone. Transmission of the record to the appeal court, February-March 2026. Once the lower court certifies the documents, the file is transmitted to the Court of Appeal. This step triggers the beginning of the true appellate phase. This period is often marked by administrative handover of documents, acknowledgement by the appellate registry, assignment of case numbers, preliminary scheduling considerations. Analysts project this transmission might occur sometime between February and March. The significance of this period is that once the appellate court receives the documents, the higher court now becomes formally seized of the matter. Any future hearings, adjournments, or procedural motions will occur at this level. Observers note this step is what closes the chapter of the lower court and fully opens the next chapter at the appellate bench. Scheduling the first appeal hearing, April-June 2026. This is the point where public interest often rises sharply. Once the record arrives at the appellate court, a date is set for the first substantive hearing. This hearing is not a full judgment. Instead, it typically involves presentation of briefs, clarification of grounds of appeal, request for additional filings, argument on procedural issues, possible discussion of jurisdictional matters. This stage is highly structured. Appellate courts focus on whether the lower court applied the law correctly, whether any procedural errors occurred, whether rights were upheld, whether the evidence was properly evaluated. Legal experts anticipate that the earliest such hearing could happen between April and June, depending on the court's docket. This stage is important because analysts believe political pathways generally do not open fully while a major appeal is active. Not because anyone is unwilling, but because the legal process must be respected. An appeal rarely concludes in one sitting. Appellate courts typically allow reply briefs, supplementary documents, additional written arguments, clarification requests. These sessions may span several weeks or months, depending on court workload, counsel availability, complexity of issues, volume of evidence. Therefore, analysts do not expect a conclusive end to the appeal until the second half of 2026. This is where the timeline becomes especially important. Political analysts emphasize that no settlement pathway can bypass a live judicial process. For that reason, many observers predict that any major movement, if it ever becomes relevant, could only occur after the appeal concludes. Based on typical appellate pacing, analysts project the judgment window around September to December 2026. This does not mean the court must rule within this period, but historically, similar appeals often conclude within this range. A judgment at this level may uphold the earlier ruling, modify it, set it aside, issue directives for retrial or review. But the most important aspect for public observers is this. Warning: once the Court of Appeal delivers judgment, the legal pathway becomes clearer. Analysts believe this is the point where discussions about policy options, national reconciliation, or political considerations, where lawful and appropriate, become easier to interpret. Until then, the appeal timeline remains the dominant force guiding expectations. Across many countries, high-profile matters follow a consistent pattern. Courts handle the legal dimension. Policymakers handle administrative dimensions. Public observers interpret outcomes. Analysts project timelines based on procedure. When an appeal is active, most governments avoid making major political commitments surrounding the subject. This is because it protects the independence of the judiciary. It prevents misinterpretation of intent. It ensures due process is not overshadowed. Therefore, analysts interpret the legal calendar as the unofficial roadmap for broader expectations. As the months move forward, each step, record preparation, transmission, first hearing, multiple sessions, judgment, brings clarity. This is why many analysts say the earliest window for any major change, if such change were ever considered, would likely fall after the appellate process concludes, not before. Based on standard pace, analysts develop two main projection windows. Window 1, early 2026, conditional. This would require a procedural decision before the appeal fully begins. Analysts generally consider this unlikely unless legally initiated by counsel. Window 2, late 2026, most conservative projection. This aligns with typical appellate duration. This is why many commentators, speaking broadly, suggest expectations around the final quarter of 2026. These projections are not promises, guarantees, or insider knowledge. They simply reflect how long appeals typically take under normal circumstances. The political atmosphere and international observation. As the appeal timeline quietly moved forward, attention gradually shifted toward the broader political environment. In every nation, sensitive legal matters also inspire commentary about unity, stability, and governance. This is natural. Citizens seek clarity, observers offer interpretations, and analysts examine how different arms of government respond to evolving circumstances. Throughout this period, many governance experts emphasize the importance of institutional balance. The judiciary following due process, the executive maintaining stability, civil society providing analysis, and international partners observing developments from a distance. This alignment creates a structured environment in which complex issues can unfold without escalating tensions. In such contexts, national discussion tends to widen beyond legality, touching on social cohesion, regional expectations, and the long-term importance of peaceful dialogue. The national conversation grows wider. Throughout December and into the new year, commentary increased on radio programs, public forums, and academic circles. The focus was not on outcomes, since outcomes belong to courts, but rather on how citizens interpret signals from leaders, how cultural and regional groups express concerns, how public expectations align with constitutional frameworks. how long-term reconciliation remains a national priority. These conversations carried a tone of reflection, calm, measured, and rooted in the desire for national harmony. One recurring idea in these discussions was the importance of understanding timelines correctly. When matters are still undergoing judicial review, expectations must align with the pace of the legal calendar, not the urgency of public sentiment. This principle guided much of the commentary from analysts and civic educators, international observers and their role. In today's interconnected world, significant national issues often attract attention from international organizations, advocacy groups, or diaspora networks. Not because they have direct influence, but because they monitor global human rights, legal processes, and governance standards. Throughout the past months, different groups abroad expressed interest in the ongoing legal developments. Their statements, letters, and commentaries did not alter the judicial process. Courts remain independent, but they contributed to global awareness of local matters. Some international voices emphasized the importance of fair trial standards, the value of transparent legal processes, the need for peaceful public discourse, the significance of national unity. Such commentary is common in democratic societies. It demonstrates how interconnected modern governance has become and how communities worldwide pay attention to one another's institutional practices. However, seasoned analysts consistently reminded audiences that international observation does not replace domestic procedure. The appeal timeline remains governed only by the courts. External commentary is simply that, commentary. The political temperature remains controlled. Despite rising public interest, the political environment remained relatively calm. Leadership figures across various sectors adopted a restrained tone, encouraging patience and trust in official processes. This atmosphere of restraint is significant. It shows a commitment to reducing tension, maintaining order, protecting institutional integrity. Governance scholars often highlight that the most critical aspect of handling high-profile national matters is ensuring stability, not allowing speculation or emotion to drive public behavior. Throughout this time, the messaging from officials emphasized respect for due process, emphasis on peace, reassurance that institutions were functioning, encouragement for citizens to remain calm. This communication strategy played a large role in preserving public confidence. The rise of civic analysis and public education. One of the most notable developments during this period was the level of civic education that emerged. Commentators, legal practitioners, and public interest organizations began publishing detailed explanations of court hierarchy, appeal procedures, constitutional powers, potential political pathways, the difference between legal and political timelines. This collective effort helped many citizens better understand why certain expectations might not materialize immediately and why legal timelines cannot be adjusted based on sentiment. Public education is critical in such moments. It prevents misinformation, reduces anxiety, and strengthens democratic culture. By explaining the difference between judicial processes and public expectation, analysts helped anchor the conversation in reality. Over time, this created a shift. Discussions became more informed, more nuanced, and more aligned with the pace at which institutions operate. Anticipation and the emergence of two-date windows. By the time January approached, analysts began forming clearer projections. Not predictions, simply logical, procedural estimates based on the appeal process. These projections gradually circulated across public platforms. Two major windows emerged. Window A, early 2026, February, March. This window is purely conditional. It would require a procedural shift before the appeal enters full hearing. Analysts viewed this as a theoretical possibility rather than a guaranteed path. Window B, late 2026, November, December. This window aligns with the typical pace of appellate litigation. Most appeal processes of comparable scale often conclude in the final quarter of the year. Public interest increased significantly around this point. For many citizens, just having a clearer sense of timing, whether early or late in the year, created a sense of structure and expectation. Analysts repeatedly clarified that these windows were not promises, but procedural projections. Still, they helped shape how the public interpreted the months ahead. The role of peace messaging and responsible commentary. Throughout this period, many leaders across various sectors reinforced peace messaging. Their statements highlighted the need to avoid inflammatory language, the importance of patience, encouragement of lawful expression, the value of respecting the courts. In a diverse nation, such messaging is crucial. High-profile matters can easily become emotional, and emotions, if unchecked, can escalate into tension. But through continuous, calm reminders, the national environment remains steady. Public influence figures, faith leaders, legal scholars, and civil society groups adopted the same tone. They emphasized dialogue, understanding, patience, national unity. This tone became one of the most powerful stabilizing forces throughout the period. 3G, the gradual build-up toward February and beyond. As the new year approached, attention naturally turned toward February, one of the earliest projected periods in the appeal calendar. It represented a potential turning point. Not because anything dramatic was expected, but because it marks the transition from preliminary procedures to more defined legal steps. Observers anticipated that by February or March, record transmission would be clearer. Hearing dates would become more defined. The appellate structure would take shape. This period, February to March, became the first checkpoint for analysts. From there, attention shifts toward mid-year hearings and the eventual late-year judgment window. How public expectation shifts during long legal processes. Legal matters with long timelines often create periods of heightened public expectation, followed by pauses, followed by renewed interest. This pattern is natural. Analysts say that such cycles occur because people seek certainty. Communities desire resolution. Political observers track trends. Media outlets follow developments. Throughout this moment, the key message from experts remained consistent. Trust the process. Let the institutions work. This message resonated widely. Gradually, more citizens began framing their expectations around the structure of the appeal, rather than speculation. As public discourse expanded, international voices continued offering commentary. Some diaspora groups issued statements urging peaceful resolution. Human rights organizations referenced global standards of due process. However, analysts were quick to remind audiences. International bodies do not direct local courts. They cannot alter timelines. They cannot override constitutional procedure. Their role is limited to observation and commentary. This clarity helped maintain grounded expectations. By the time we reach the end of this section, three major expectations dominate public thinking. 1. Clarity in February, March, when early procedural steps become fully visible. 2. Major hearings around mid-year, as the appellate court begins substantial review. 3. Greater certainty toward the end of 2026, when judgments or appellate conclusions become more likely. Through all of this, the underlying theme remains the same. White medium star: the legal timeline, not public pressure, determines the pace of events. White medium star: the political atmosphere remains calm and measured. White medium star: public educators continue promoting patience and unity. These factors combine to create a stable environment in which the nation can observe due process unfold. In the concluding segment of this documentary, we will explore how these timelines may influence 2026, why analysts believe national unity will remain the priority, how slow, steady institutional processes shape long-term peace, and what observers expect in the months leading up to the appeal judgment window. Part 4 brings everything together into a final, calm, balanced conclusion. Long-term outlook and final analysis. As the appeal timeline extends into the latter months of the year, analysts emphasize that the broader national landscape is shaped not just by legal processes, but by the tone of public discourse, the consistency of institutional messaging, and the patience of the citizenry. In this concluding part of the documentary, we explore how all these elements converge to form a realistic outlook for the coming months, and what observers expect as the legal calendar advances toward its natural conclusion. Why 2026 is a year of structured expectation. With the fundamental timelines already established, early procedural milestones, mid-year hearings, and a potential late-year appellate resolution, 2026 becomes a year of structured, predictable phases. Observers note that this structure is helpful because it prevents uncertainty from dominating public conversation. The public can now frame expectations around legal rhythms rather than speculation. This predictable pacing stabilizes the national atmosphere, reinforcing trust in institutions and reducing the pressure for premature conclusions. Across media and academic platforms, commentators highlight that 2026 should be seen as a year of methodical, step-by-step progression. Each month reveals just enough movement to maintain clarity, while respecting the independence of the judicial process. This principle, steady movement through lawful procedures, is at the heart of the long-term outlook. How national unity shapes the narrative. Throughout the year, the recurring theme across policy forums, editorial discussions, and civic conversations has been unity. In a diverse country, maintaining cohesion during sensitive legal matters is essential. Scholars of governance note that unity does not mean uniformity. Instead, it means sustaining a national environment where differing views coexist peacefully, and where institutions provide the structure that prevents tension from escalating. Several factors reinforce unity during such periods. Consistent messaging from authorities encouraging peace. Calm analysis from civic educators. Patience from the general public who choose understanding over speculation. Respect for judicial independence, minimizing external pressure. These elements create what political scientists describe as institutional resilience, the ability of a country to maintain stability even when navigating complex matters. As the appeal timeline moves ahead, unity remains the steady foundation that allows the process to unfold peacefully. The limits of prediction. Why outcome remains unknown. One of the most responsible positions analysts have emphasized is that no one can predict the outcome of an appeal. Courts decide based on fact, evidence, legal argument, judicial precedent. Observers can understand the timeline but not the verdict. They can interpret public statements, but not confidential judicial reasoning. This distinction is crucial. It prevents misinformation, protects the integrity of the process, and ensures that the public remains grounded in what is known rather than what is imagined. Because of this, the most accurate outlook is not speculation on the verdict, but an understanding of when key procedural steps occur, what those steps typically lead to, how the timeline aligns with broader governance considerations. Thus, while the outcome remains unknown, the pathway is clear. The role of peaceful civic engagement. Another important aspect of the long-term analysis is the growing trend of peaceful civic engagement. Citizens, advocacy groups, and community organizations increasingly choose measured, lawful channels to express their views. Examples include writing open letters, hosting academic roundtables, publishing commentary, engaging in non-inflammatory discussions, creating awareness around due process. These forms of engagement have a stabilizing effect. They allow citizens to participate in national discourse without generating tension or conflict. Analysts observing this trend note that it reflects a maturing civic culture, one that values dialogue over disruption and clarity over speculation. This civic maturity strengthens trust in institutions. And trust, in turn, allows complex processes, such as lengthy appeals, to unfold without destabilizing national cohesion. Why many analysts focus on the end of the year. As earlier sections established, the typical appellate timeline for complex matters often culminates in the latter months of the year. Based on procedural patterns, analysts expect that April to June will bring the first major hearings. July to September will include follow-up sessions. September to December could be the window for appellate decisions. These expectations do not bind the court, they simply reflect historical pacing. It is within this context that analysts shape their projections. Many emphasize that any significant shift, whether political, administrative, or conceptual, typically emerges after legal clarity is achieved. This is why the final months of 2026 attract more attention in analytical circles. Not because a result is guaranteed, but because procedure points toward that horizon. The importance of responsible media in sensitive periods. Responsible journalism plays a powerful role during extended legal processes. Media outlets, especially those with national reach, carry the responsibility of avoiding sensationalism, presenting facts calmly, clarifying timelines, educating the public, preventing misinformation, encouraging peaceful dialogue. Truthline Africa's hallmark style embodies these principles. Calm narration, factual storytelling, neutral analysis, and respect for institutional processes. During moments of high public interest, this style becomes essential for maintaining a stable, well-informed audience. It is through responsible media that citizens gain clarity, anxiety is reduced, national unity is strengthened. This documentary itself is part of that ecosystem, providing structured understanding rather than speculation. What the next 12 months may look like. When analysts look ahead, they often describe the next 12 months as unfolding in three broad phases. Phase 1. Procedural clarity, January, March. Documents move through administrative channels. The court confirms readiness for appeal. Public expectation becomes more focused. Phase 2. Substantive hearings, April, September. Lawyers present arguments. Judges evaluate evidence and legal grounds. Public discourse becomes more analytical. Phase 3, Judicial Resolution, September, December. Appellate decision is reached. Legal clarity emerges. Observers reassess the broader national picture. These phases offer structure without assuming outcomes. They give citizens a realistic sense of pacing. National stability as the central priority. Throughout every phase, one theme remains constant. National stability. Governments across the world prioritize stability during sensitive judicial processes. This is not unique. From Europe to Asia to Africa, public institutions adopt measured tones, balancing transparency with restraint. Analysts consistently highlight that stability ensures protection of rights, predictable governance, peaceful civic environment, confidence in the justice system. By maintaining calm, institutional leaders support a national atmosphere where due process can unfold without undue interference. A look at the broader political landscape. While the legal process continues, the political system also moves at its own rhythm. Budgets, development projects, regional consultations, and policy initiatives. These processes do not pause for judicial matters. They operate parallel to legal proceedings. This parallel movement reminds the public that governance remains ongoing, dynamic, and multifaceted. As the appeal progresses into mid-year, political actors focus on national development. Regional leaders manage local priorities. Federal institutions pursue economic and security agendas. This continuity is healthy. It ensures that the judiciary handles its responsibilities while governance maintains momentum. The final outlook, what analysts emphasize. After reviewing the timelines, public discourse, and institutional behaviors, analysts consistently return to three central conclusions. 1. The appeal timeline is the anchor. All meaningful expectations revolve around document preparation, record transmission, mid-year hearings, late-year judgment window. This timeline structures the year. 2. Stability and unity are the national priorities. Throughout the process, leaders emphasize patience, calm, and trust in institutions. 3. Outcomes cannot be predicted. Only the courts determine outcomes. Analysts can describe pacing, not results. These conclusions shape the long-term outlook with clarity and responsibility. As always, peaceful engagement remains the strongest foundation for progress. The appeal timeline provides structure. Civic understanding provides stability. And national unity provides strength. This concludes our full-length analysis of the appeal calendar, public expectations, and long-term outlook for the coming year. Stay informed, stay safe. This is Truthline Africa.